when you created the sublease agreement with the plaintiff, at that point in time, did the landlord agree verbally that the security deposit would be provided by him instead of you?
Yes, he did, and I didn't think to...
I was going to ask you, why didn't you include that?
He was doing me a favor by letting me sublease to someone, so I didn't want to burden him with like having to sign contracts and stuff, which I should have, and I should have put it in there, and I should have made him sign it as well. But I thought she was going to sign a lease before my contract was up, and that was the incentive to have my deposit come from the landlord.
Wait, but I thought you said she stayed past.
She did, and it was always my intention that she would stay for a couple months, pay rent on time, and then sign a lease with Leo, and I would get out of my lease.
When was your lease up? Like, let's say she never moved into
the end of
apartment.
September.
And at the end of September, you were going to go to your landlord and expect your security deposit back.
Yes.
Why would it not make sense for you to do that instead of her going around you and getting your security deposit? Why not get your security deposit from him and she comes to get her security deposit from you?
I guess that I needed to pay another security deposit for the place that I moved into. I needed to navigate the situation.
I get it.
I don't exactly know why I didn't just wait until the end of my lease, but I didn't.
Any more questions from my colleagues?
Yes, I do. So now I think I have a better understanding of the text message that you referred to.
Mm-hmm.
You say, you'll get your deposit back from Leo should you choose to sign a lease. If not, you'll get it back from me, as long as the rental agreement isn't broken. And what you meant by broken was you give me 30 days notice and don't miss the rent or damage the property. At the time, she asked you for the $2,000 security deposit back. You had already finished up your lease responsibility.
Yes.
So it didn't make sense to give you the 30-day notice because it would have been meaningless to you. You had moved on, and she was essentially a holdover sublessee with the permission of the landlord.
Mm-hmm.
It seems fairly clear to me what the outcome, unfortunately, should be, but I'll discuss that with my colleagues. We'll excuse both of you. Thank you very much.
Thank you.
This courtroom is now in recess.
So unfortunately on this one, I think the person that really created the underlying problem here is a third party, the landlord, who's not present and who can't really answer for the issues we have. Unfortunately, though, and I believe for the defendant in this case, there's a very well-established and basic principle under the law called privity of contract, which establishes pretty clearly and pretty simply when two parties contract, they can't confer rights, and particularly here, obligations, onto another third party. That's for obvious reasons. You know, if Michael and I wrote a contract saying Yodit will pay me $1,000, that would be completely unfair for me to come to Yodit and say, well, where's my $1,000?
Although certainly I'd expect it.
Right. So it's a common sense principle, but it's also a legal one. The defendant cannot obligate the landlord to return the money to the plaintiff. And her kind of secondary on the fly defense here that she breached the agreement, it may be technically true that she didn't provide 30 days notice, but landlords, you know, which the defendant was here under California law, have very strict requirements. You cannot keep a tenant's security deposit, even if there was a technical violation, a failure to provide notice. So I think the defendant is responsible for the money.
Yeah, I agree with your analysis.
Yeah, I mean, she obviously was in over her head. I mean, she didn't even abide by her own terms. Yeah. I think it was one of those like Google boilerplate, you know, landlord agreements, but she kept the security deposit in her own checking account. I agree with you too that she's responsible, so.
We have a verdict?
We do.
In favor of the plaintiff for the full amount?
$2,000.
Yeah, the full $2,000.
Yep.
Yeah.